Good morning. Can I welcome everyone to this, the first meeting in 2014 of the Justice Committee. I feel as if we've never been away. A good new year to everyone, including all our witnesses and in the public area. Can I ask everyone to switch off mobile phones and other electronic devices completely as they interfere with the broadcasting system, even when switched to silent? No apologies have been received. Item 1. I'm inviting the committee to agree to consider items 3 and 4 in private. Item 3 is consideration of a draft report on the proposed Public Services Reform Prison Visiting Committee Scotland Order 2014. And item 4 is consideration of the evidence received to date on an LCM related to forced marriage. Our members agreed to take items 3 and 4 in private. Thank you very much. Item 2, Criminal Justice Scotland Bill. Is it too fast for you? I'll slow down there for you, Margaret, till you get your bearings again. Right. Our next item in evidence from the Cabinet Secretary for Justice and the Criminal Justice Scotland Bill. The Cabinet Secretary will be giving evidence today on Part 1, Arrest and Custody, Part 4, Sentencing, Part 5, Appeals and the Scottish Criminal Cases Review Commission, and Part 6, People Trafficking, TV Links and Police Negotiating Board for Scotland. So I'd remind members to keep to those segments. That's my mot du jour segment. And we'll move on to the other items next week. So we'll start by looking at Part 1 of the bill before we have a break to allow some officials to change over Parts 4, 5 and 6. And for now, I welcome to the meeting Kenny McCaskill, Cabinet Secretary for Justice and Scottish Government officials, Elspeth MacDonald, Deputy Director, Criminal Justice Division, Leslie Baga, thank you, Criminal Justice Bill Team Leader, Eileen, somebody should tell me how to say it, Bearhop? Oh, there we go. Why can't you have Smith? It's so much easier. Head of Police Powers Team, Jim Devoy, Police Officer, Youth Justice, and Anne Hampson, Policy Officer. You're a good person. Policy Officer, Victims and Witnesses Team. I understand, Cabinet Secretary, you wish to make a brief opening statement, and then I'll go and take questions from members, and be ready with your hands up to get on my list. Right, thank you very much.
Well, thank you, Convener. A good new year to you and members and all as well. I welcome the opportunity to give evidence today on the Bill's provisions relating to arrest and custody, sentencing, appeals and other issues. In this opening statement, I'll focus on police powers and rights of suspects. We all want Scotland to have a modern and effective criminal justice system, one fit for purpose and which properly balances the rights of individuals and the duties of the state, and I believe the provisions within the bill deliver that system. The bill clarifies and modernises police powers of arrest. It streamlines the current police powers, moving from detention followed by arrest when a sufficiency of evidence exists to a singular power of arrest and suspicion of having committed an offence. The provisions improve the law and will be easier for the police to apply than the current system. The statutory arrest power replaces the complicated landscape of common law and statutory arrest that currently exists. It brings the Scottish system more in line with the European Convention on Human Rights, which refers to arrest as the initial deprivation of liberty and detention as the period of police custody following arrest. The bill recognises that modern investigations are often complex and protracted. And in line with the recommendations of Lord Carloway, the bill balances the needs of a thorough police inquiry with a suspect's right to liberty, for example, through the introduction of investigative liberation. The provisions in the bill put Scotland at the forefront of human rights protections. The bill extends the rights of those held in police custody. Everyone will now have the right to speak to a solicitor, regardless of whether or not they are going to be interviewed by the police. It provides greater protections for children and vulnerable persons held in police custody. The committee has heard evidence from representatives of various organisations involved with the criminal justice system, and I have listened to their views and concerns. As a result, I intend to propose a number of government amendments to the bill. One area where change is needed is to provide for the release of a person from arrest when the grounds for that arrest cease to exist. This has been referred to in evidence as de-arrest. I will be proposing an amendment to Section 4 of the bill to provide for a de-arrest provision. I am also aware of police concerns about the 12-hour limit for keeping persons in custody and the need to consider provisions to allow an extension in exceptional circumstances. And there is a serious issue here about balancing the right to liberty of an individual against protection of the public, and I am continuing to listen to all the arguments for a potential extension in exceptional circumstances. The police powers of detention and arrest, both at common law and statute, have served Scotland well. However, it's time to modernise our systems and recognise that modern-day investigations require modern-day legislation. We must ensure that the public are protected by police who have the powers to do the job we entrust them to do. We must also protect the rights of individuals whilst in police custody. And I'm grateful for the opportunity to answer your questions on these and indeed other provisions of the bill.
Thank you very much, Cabinet Secretary. And also, it was remiss of me, and I'll not be forgiven, to not welcome Graham Pearson to the committee. He seems to want to join us on many, many occasions. You're welcome back.
Thank you.
That's nothing, just felt my good mood. I want us to start off the arrest and police custody as a section, if that's all right with everyone, before we move on to others. So questions. Elaine, followed by Mary.
Thank you, Convener, and Happy New Year on the record.
Margaret, sorry, I beg your pardon.
Margaret.
Elaine, followed by Margaret. Yes.
You've explained in your opening statement a bit about the definition of arrest and detention being the period after arrest when you're being questioned. The problem, I suppose, is that the public perception of arrest and detention is slightly different. That arrest, in the public mind, if you like, is when the police think you may have done something and charge you, and that you could be questioned prior to that. Do you think that there is a possible damage to people because of this perception, or because of the current situation, that there could be damage to the reputation of those people who are arrested but not actually then gone on to be charged?
No, I don't believe so. I understand where you're coming from, and I recognise the point that you're making. I think a lot of those points you make relate not to the nomenclature or the statutory definitions relating to arrest or detention, they relate to media profile. For example, the high-profile case down in England a year or so ago, never mind the fact that I don't ever recall any prosecution against Nigella Lawson, but every time I saw the television, I thought she was on trial. But that's how matters were portrayed by the media. That's for a separate debate and separate ways. I think clearly in Scotland what we have to remember is what remains sacrosanct is the presumption of innocence. Though somebody may be arrested by the police, they are presumed innocent until it is proven otherwise conclusively by a court. And I think that is recognised by all in Scotland, though sadly sometimes that doesn't appear to be portrayed sometimes in the media. So I think we have that aspect there. Equally, I think we have to move towards the European definition, I think correctly, of arrest and detention. I mean, the concept of detention is relatively new in Scotland, and no doubt Mr Pearson and Mr Finney will be able to confirm as well. I started out doing my degree in law, and it didn't exist. By the time I became a law apprentice, they brought in the 1980 Criminal Justice Act. So what I had been taught by Charles Sturrett had been superseded by an act in 1980. So detention has been with us only since the 1980 Act as such. And I think what we're doing here is getting greater clarity. So I think in a nutshell what this provides is clear definitions between arrest and, as I say, detention, I think are beneficial and will be not simply here but across other jurisdictions. What we have to do is also to remember, though, that those who are arrested on a suspicion, and it is on suspicion only, are presumed innocent, and that is how it will always remain. And I think we all have to perhaps work with the media to make sure that people who, for whatever reason, and indeed one of the high-profile cases I think we're referring to, I don't, and sometimes it's not even that they're arrested, it's simply that they're interviewed by the police.
Do you have it? I mean, I understand what you're saying there, and I think there is if we listen to the media from England, sometimes I myself have had a misapprehension of what an arrest has actually meant when somebody's been taken, probably thinking of that particular case that you're talking about. Are there ways in which we can, if this goes into legislation, that we can actually tackle the public perception so that if somebody is arrested, there's not a presumption that they've actually done something?
Well, some of it might have to be for another day, certainly dealing with the media, but I think this provides greater clarity. I think if we were to go out and ask ordinary citizens in Scotland what the difference is between arrest and detention, why some people are arrested straight by the police and some people are detained by the police, it would be pretty hard and difficult sometimes to explain the difference. I think where we're heading to is the correct desire of the coming from Europe, that there should be a clear difference between detention, which is when your liberty is deprived, and indeed arrest when, as I say at the outset. So I think that might take some time, but I think heading in that direction will actually be a lot clearer than Scotland, where you're detained under the 1980 Act, but you can be arrested under common law. I find that's probably harder for people to understand. I think once it becomes quite clear that detention is when actually you are detained and your liberties affected, as opposed to the point of arrest, which is where there's a suspicion of an offence. So I think greater clarity will come as we perhaps roll back from what came in 1980.
Do you think, Cabinet Secretary, that, and I subscribe in part to what's being said by Elaine Murray, and I agree it's a matter of the media, but the media, I don't think, are going to be contained in that way. Do you think there may be room at some point in considering anonymity for accused parties in certain cases that is provided to the principal witness? If we're going to move to arrested, not officially accused, in certain very serious cases, when we think you get the public saying no smoke without fire. In that previous case in London where that man's life was pretty well ruined and he had to change his appearance and all kinds of things, and presumably he's never got over the fact that he was tried by the papers and to some of the public will still be found guilty by the press. It's not something we can do in law that would provide protections.
Well, I mean, it's a jurisprudential debate that I think we can have. I think the only caveat I would have nowadays is, given the world of social media, when we've seen various high-profile footballers who've had court orders of anonymity south of the border appear on the front page, albeit with, I think, some masking of their eyes, and everybody, you know, who had any passing semblance in football knew who we were discussing or who was on the front page of the Scotsman newspaper. So that's a matter I'm always happy to look at, because these things do have great consequences and effect. The difficulty is, in the world of social media, even with a court order, if it's coming from a different jurisdiction, if it's available on Twitter or on YouTube, yes, it's pretty hard to enforce. But
nevertheless, it would be breaching, if one were to go down that direction. Quite rightly, we have protections for principal witness in certain kind of cases, particularly sexual offence cases and rape cases. It may be worth a consideration, that's all I'm saying, is to allow that protection to the accused in these circumstances when we now have, you know, in custody in a person not officially accused, which does seem to take it a step on from mean perception. I appreciate the difficulties of the media, but that applies to all of our laws.
Well, you know, you're correct. It applies at the present moment to minors, unless the court were to specifically exclude that and allow for publication. At the present moment, the young person's name would not be published unless decided otherwise. So these are matters, you know, we don't have a formal policy. We're happy to, as I say, consider and engage with the committee and with the legal profession, and doubtless with the media and indeed those in social media, because, as I say, I think there's a legitimate and understandable point raised by you. The devil is always in the detail, especially in social media.
This committee knows that, but I'm just saying, I just popped into my head and I thought that it's maybe an opportunity to give consideration. And so there's some traction behind this now, I think, that in certain cases, notwithstanding the protections at the moment the court allows, people are tried by the media and have to live with it on both cases, witnesses as well. And I think there's issues there to be examined. I now have Margaret, Sandra, Alison and John Finney.
Good morning, Cabinet Secretary. Happy New Year to you. The committee took evidence on the 1st of October from various police witnesses. John Gillis of Police Scotland told the committee that the change from detention to arrest on suspicion would result in considerable additional training requirements and also resources. The kind of feeling that we were getting from the police was that they didn't think, regardless of what the Cabinet Secretary has said about modernising and streamlining the law in detention, they didn't think that this change was justified in terms of the additional burdens that it would put on Police Scotland. Could you comment on that?
I don't think that is the evidence of Police Scotland. I have no doubt that John Gillis did indicate that training would be required. We accept that, and that will be factored into timescales about when and how this is brought in, if passed by Parliament. But Police Scotland support the general thrusts of the bill, and any change, whether it was the 1980 Act or indeed the 2014 legislation, will require officers to review, learn again, and indeed procedures. We've been through that with We've been through that with Cadder, where officers had to be given cards to be able to, as I say, read out matters that hadn't perhaps been taught to them when they had first passed through Tullyallen. So I think Police Scotland are content. They understand the obligations that go with any new legislation, but that applies to every Act of Parliament that we pass, where they have to take it on board and act accordingly.
Well, could I perhaps put to you what Callum Steele said from the Scottish Police Federation? He said a change from detention to arrest had not been made, and I've yet to hear a cogent argument for why it makes something better to change terminology largely without changing content. And I fear that consequences of the wrong information being recorded because officers are dealing with a new set of processes, even if the general principles of fairness are applied, could lead to cases being thrown out of court.
I don't believe that is the case. I think actually what Lord Carlaway is proposing, that's part of a general direction within Europe, will make things clearer, because we are moving from a current position where you have to make a decision as an officer whether to arrest somebody or whether to detain them under the 1980 Act. This will make it clearer. You will simply arrest them on the suspicion. It has to be a reasonable suspicion. So I think matters will be clearer for officers, though I do accept the point made by John Gillis that they'll require to be given some, as I say, training in that. But I think it actually simplifies matters, and it comes back to the point first raised by Elaine Murray in terms of the understanding of detention and arrest. And I think at the present moment we have arrest and detention that frankly blur into each other. I think we should head towards a situation which I think correctly was encapsulated by Europe, that arrest should be at a point of when a suspicion is made and detention should be the deprivation of your liberty. Do have to see how that's interpreted by the media and by the general public, but I think there's greater clarity there than currently exists with, is that if somebody were to be detained by a police officer now, would they be arrested, would they be detained? The current answer is it could be both. It would depend upon what the officer had decided and which act he was following. I think it will be clearer once this legislation is passed, because they will simply arrest them. There will be a point when they're detained, but that arrest will be made by them on suspicion. So I think that actually makes matters clearer.
So in that case then, you wouldn't agree with Assistant Chief Constable Green of Police Scotland, who feared the new definition could prevent arrest in order to prevent a crime taking place. You're quite satisfied that arrest on suspicion fully covers that.
Yes,
and you don't feel, therefore, that there's a need actually to implicitly make the power to arrest to prevent a crime something that was contained in the bill?
Well, common law powers for arrest remain, and that is always there. So, the Association of Scottish Police Superintendents raised that. I think they were correct to raise the concerns they have, but we can make it quite clear to them that the common law powers of arrest remain. Other than that is being changed with the formal statutory arrest procedure. So arresting, as I say, on prevention, or rather, indeed for public safety, remains.
But I understood from your opening statement that you were clarifying the common law in statute. Surely this would be an opportunity to make sure that the arrest for prevention was clearly something that was within the police powers.
We are doing away with common law powers of arrest and putting it all within Part 1 of the bill, so it's just a statutory power. Other common law powers will continue, so they're not affected at all. Our concern about putting a prevention power in is what are you actually going to be arresting somebody for if they haven't actually committed a crime. The bill allows for somebody who is actually committing a crime to be arrested.
Okay.
So if you've got a brick in your hand next to a car window,
I think that's an intent to commit a crime.
But that would be under the common law.
If there's a brick beside you on the pavement and you haven't actually done anything to move towards that, then you
say
haven't
you've got it in your hand and you're looking at the car window.
I think
that wouldn't be covered by this, though, because you're not committing an offence. You could just be holding a brick.
It's a police operational decision as to at what point does that person become somebody who's going to commit a crime.
That, in terms of this,
that would be committing a crime in the act of.
That's under this section. You're committing an offence to stand with a brick in your hand looking at a car window.
Because you're.
Okay, I'm just asking. It's difficult to know you could defend yourself. I'm a brickie. It's my car. You know, I just wondered, it is difficult. So in common law, you'd be able to just explain that, what the common law provision to deal with that.
That's not the common law, that's just an operational decision. At what point are you committing a crime?
Okie dokie, right.
And there are also statutory powers within, I think, the Civic Government Scotland Act, which allow the police to pick somebody up if they're in, for example, a known housebreaker who's got housebreaking kit on them and walking towards a building.
What's housebreaking kit?
Is it a T-shirt? Or if you're in a building where you shouldn't be, looking like you're about to commit a crime. So there are other powers.
Sorry, Margaret, I just was intrigued by this.
Could I then just tease out, this is a new offence, suspicion to create crime, and how would that differ from how prevention, arrest for prevention of a crime would be treated?
Just been handing a note here that's telling me from the lawyers that there is a common law offence of attempt to commit a crime and conspiracy, which will still be there. So that's something else that.
We're getting into esoteric complaints. I mean, if somebody is conspiring to commit armed robbery and there is evidence of that, then they will be arrested. If somebody is, you know, with a brick in their hands, looking about to put it through a car window to take whatever handbag or elsewhere is lying, that is, clearly a crime about to be committed. The difficulties that come for police and for law enforcement come to some extent from the position that we have no jail as such for thought. There are people out there who we think might be thinking of doing offences. Unless we can show any conspiracy, we're not really able to charge them. There are instances, specific statutory matters, as Aileen's referred to. If you're in the curtilage or in a common close and you've got screwdrivers down your back pocket and it's not the stair that you're in and you know no reason to be there, then I think an assumption can be made, and especially if you've got previous convictions that would have you detained. I think I'm trying to remember if it's the Civic Government Act or be detained there. So to say, the difficulty is whether when people are thinking about doing matters, unless you can prove it, unless it's a sexual matter, you can go and get a SOPO or you've got them on OLRs, there are difficulties. These provide huge challenges to all jurisdictions, because what would you charge them with if you arrested them? We think you're thinking of committing an offence. What offence? You know, we know that they perhaps have a propensity for doing evil things. These cause real problems, which is why we've created, as I say, sexual offence protection orders, these other aspects. But the standard ones, perhaps, somebody standing with a brick, somebody with screwdrivers in their back pocket going into a common close, these aspects can be dealt with and would be dealt with under the new statutory provisions.
And would you envisage that police would need more training for...
No, I think what the police are looking to do here is when any new legislation comes in, is as with post-CADA, to make sure that they can give them. I don't think they're going to be doing this in isolation, and indeed that's Lord Carloway has, I think, taken a provision from the point of first suspicion through to the ultimate appeal. There's going to be a whole area of legislation that police are going to have to get trained up to and realise that there's been changes. So that's matters that they'll work through. It's discussions that we've had with them. They'll take time to make sure that training is given. Some of it will be on job, some of it will be online, some of it may be at Tully Allen. That's a matter for John Gillison from the Senior Officer Command Team. But as I say, it happened post-CADA only a few years back, and as I say, I think the police showed that they were able to deal with it. I don't think people noticed a change as such in terms of the quality of service out there in our communities.
Finally, Convener, there was some concern expressed about the provision where the person arrested had to be brought to a police station as soon as practically possible, and the concern that there was a lack of flexibility in that provision. Could you comment on that, Cabinet Secretary?
Well, I mean, in terms of being taken to a police station, I mean, obviously it's in terms of interview, unless, you know, and there's exceptional circumstances where, for example, in a kidnapping or whatever, where access would be denied, but they will be very, very few. Other than that, if somebody is arrested, then they will be taken to the police station where, you know, they will be advised by their letter of rights that will be available in a variety of languages, scripts to assist. Indication will have to be given by the officers and senior officers as to whether they're vulnerable, the age, etc., and capacity, and access to legal advice will be then offered.
Lord Carloway's recommendation was less rigorous and said those arrested should be taken only to the police station only when necessary. Why has the government gone that little bit further?
I think was your first point about it was about as soon as reasonably practicable.
And that's possible, but
yes.
I think the implication was every single person arrested would have to be taken to
and answer to your first point was that as soon as reasonably practical is just recognising the fact that in some cases it will take longer to get somebody to a station, for example, in a rural area. What the Minister said in his opening statement about de-arrest recognises that there will be cases where somebody who has been arrested, the grounds for arrest, then stop, or for some reason they're no longer should no longer be under arrest, and in that case we're going to change the bill so that that arrest can be stopped and the person can be released straight from the street rather than being taken to a police station to then be sent home.
But Lord Carloway's recommendation was only when necessary. I mean, it was suggesting never mind the de-arrest, which I think muddies it. And I must admit, I'm not a great fan of de-arrest. It sounds to me a bit confused, however.
I think, well, the reason for somebody to be taken to the station is recognising the need to give people the rights for them to have access to solicitor, for the proper recording to be made. So that, you know, you're going through the right process with an individual.
And that's for every single crime. Isn't that going to change quite dramatically the way things work in practice just now?
If you can charge them on the street, they would not have...
Well, many of the CADR challenges that we faced, let's remember, some of them post-CADR related to statements or admissions made at scenes of road traffic accidents or other such aspects where they hadn't been cautioned. So I think there's good reason that wherever possible, they should be taken as quickly as possible to a police station. As I say, we did face challenges with people at the scenes of road traffic accidents, having said, well, you know, if you admit the driver, then you can be putting yourself in a position that that can be incriminatory. So there's good reason to make sure that if you're wanting to interview somebody, then it's at that police station or a point of arrest. We have to have some latitude in that because Scotland is not a uniform country. We do have rural and isolated communities. These challenges happen very rarely, but I have heard of officers in Shetland, for example, where to arrest somebody they've had to hire a boat because it's not part of the beat. It's one of the smaller islands within the Shetland Islands. To go to the island actually takes time to actually get there. We have situations on other larger islands closer to the mainland in Scotland where there is no lawyer present, but where a death has occurred in a Section 1 road traffic accident. And again, you know, we've got to make sure that there's latitude. So this is about making sure that we get the fairness to the accused. When the police have formed a suspicion, and that person has that right to know, they should have that right to legal advice, which is why I think that cannot be dealt with in the main, at the roadside, in the common close. It should be down at the police station where things can be formalised and you can balance that right between officers who would be seeking to interview with the availability of advice for those who may or may not wish to make any comment.
Just for the avoidance of doubt, Convener, can I just say that every single person must be taken to the police station at one point or other under this legislation?
Not if the officer decides that they can charge them immediately. They can be charged and released for appearance at court at a later date.
I mean, that's to
Just
deal
one-
with the very minor matters. If somebody's, if an officer goes out tonight and somebody's urinating in the street, I think we know the challenges that police face. It's unacceptable behaviour. If it happens and you're close or whatever, it's downright offensive. Do you need to take officers off the street to take them back to the police station? Well, there might be if their behaviour was becoming unacceptable, but it might be you just deal with it there and then. So this is about providing flexibility for the officer out in the street to make that decision. If somebody requires to be taken off the street and interviewed, then it's got to be, as I say, I think we've got to begin to balance the rights. If there's something where the behaviour is unacceptable, it can be dealt with at a later date and we can move on. Then obviously they don't have to accept the ticket, they can challenge the ticket, it can be dealt with. So as I say, it's providing that flexibility for the officer in the circumstances.
Yes, Ministers, thank you very much. A very, very full explanation. I want to move on to supplementaries on this particular line. Both of you have got Roderick first, then John Finney, right?
No, mostly covered what I was going to say or what I was going to ask it in your most recent response. But just in terms of the reasons why someone's been taken to the police station, however, I think the Scottish Law Commission, the Scottish Human Rights Commission suggested that there should be more statutory definition of what those reasons are. Would you like to comment on that?
I mean, we're happy to consider that. I think we need to be spelt out just what it is that they're suggesting. I mean, what we are seeking to do, and I've had discussions with SHRC to make sure that the letter of rights, that people understand what it is that is happening to them, that, as I say, is contained within the letter of rights, what their rights are, what may happen thereafter. Other than that, I tend to think that the best thing that we can do in those circumstances is let them know if they want additional advice, and that's through access to a lawyer, either by telephone or in meetings, depending on the views and wishes of both the individual and their legal representative. I think that's the best way of addressing matters.
Thank you.
John.
Morning, Cabinet Secretary. Cabinet Secretary, if I noted you correctly, you said common law and statutory powers of arrest have served us well, I think was the term you used, and you went on to say that the common law powers remain. I wonder, in relation to the progression of changes that have taken place, do you think that the 1980 detention legislation was an improvement on the previous situation?
I don't think I'm able to comment on that. I mean, I think I did my evidence and procedures, I think, in 77, and the Act came in 1980. So my practising life as a lawyer started with the 1980 Act coming in. It was just kicking in when I was a law apprentice. I was the last of the jurisdiction of law apprentices before they moved to trainees. So I have to say I have a historical training from Sheriff Stoddart as to what the common law from Sheriff Gordon's textbook, but all my practical life we've had detention, so I don't think I'm best qualified to comment, but I think what it does show is it's not been with us forever, and I think my view is whether people are arrested or detained, to some extent what mattered was they were down at the police station.
But of course, prior to 1980, people were down the police station in courts helping police with their inquiries and having a very indeterminate status. That formalised an arrangement that I would have thought the legal profession welcomed.
Well, I think that the helping with police inquiries was a euphemism that could have a variety of meanings, some of which were very perfectly acceptable, some of which I think began to, perhaps go to the margins of what would be viewed as acceptable. So I think there was greater clarity there. That's why, as I say, I think Lord Carloway has gone away and looked at matters. And as I say, I think where I think he's quite correct is it's almost, from a public perspective, sometimes even from a police officer, it might be a judgment call or arbitrary whether you arrest or detain. Equally, I do think that if people are in police custody, then various things have to kick in particular access to rights, the availability of legal knowledge, and therefore the helping police inquiries, I think, is something that we could not and should not go back to.
I agree. I wonder, you would acknowledge the purpose of the power of arrest would change if this legislation went through. And what would the purpose of the power of arrest be?
Well, I don't necessarily think that it would change. I mean, I think police officers detain people when they think a crime, has occurred or is about, to occur that has to be interceded with. And I think you know, as I say, there are issues, doubtless instances you might have been through, and probably would have been through more than me, about whether you decided to detain under the statutory powers or whether you arrested under common law. I think this makes it clearer. You will simply arrest on suspicion. You will have that basis. It won't be flimsy. It won't be you don't like the cut of their jib or the walk of their gait. It will have to be that something has happened. There is some clear position there, and immediately that happens, rights kick in for the accused, because we have to have that balance retained. So I actually think this provides greater clarity, and I think it certainly will provide greater clarity for the man or woman in the street who probably wouldn't understand that they had been detained under the statutory powers for 6 hours, or that they had been arrested. All they would know is that their son, husband, or whatever was down the police station.
The very first section of the legislation says, and I quote here, a constable may arrest a person without a warrant if the constable has reasonable grounds for suspecting that the person has committed or is committing an offence. Do you think there's any possibility of a reduction in people being reported for summons, given that?
No, I think this will come down to, you know, good practice. At the end of the day, what we don't want is to have officers off the street where they've seen matters happening that can be dealt with by fixed penalty notices or a variety of ways. So I think this is simply about allowing officers to use their discretion, what can be dealt with in other ways by simply noting matters, giving information, providing fixed penalty notices. We want to keep that rolling because I think it's a matter of balance for both. I think people would prefer, if their behaviour has been unacceptable, can be dealt with by a fixed penalty notice, simply to accept that fixed penalty notice and to go away perhaps suitably humbled, as opposed to being taken down the police station for many hours. So I think this will be how it is implemented in practice, but I have no reason to believe that the police will not continue to use, which I think is at the core of policing in Scotland, which is the discretion.
I agree, discretion is the strongest power any constable has. The second section qualifies that power of arrest by saying only if the constable is satisfied that it would not be in the interest of justice to delay the arrest in order to seek a warrant. The third section then lists the circumstances in which it would be legitimate. If the common law powers of arrest have served as well and will be in place, why is section 1.3 not the common law powers of arrest rather than narrated as it is?
I think we recognise the need just to be clearer in law about what police officers are arresting for, and the bill is clearer than the current position, where I think some police are using common law powers of arrest because they're not entirely sure what the proper statutory power of arrest might be.
Well, I mean, I acknowledge I might be extremely rusty on this, but things about no fixed abode, name and address, not believed to be correct, or they don't seem to feature in that at all.
What about the catch-all otherwise obstruct the course of justice, John? Does that not help?
Well, my point, Convener, is if the common law powers have served as well, why aren't they reproduced there?
I think we considered that the wording of that particular provision was sufficient for the purposes of arrest in Scotland.
So, just to clarify, will section 1.3 supersede the common law powers? Or are we in for one of these many legal debates under...
There will be no common law powers of arrest.
All right. Sorry, I understood the Cabinet Secretary to say that these powers will remain.
There will be no powers of arrest. We talked about there being common law powers of attempting to commit crimes and the prevention arrangements, the question that came up earlier. But
in talking about the difference between the common law powers, the ones that are remaining are ones that are not criminal common law powers or common law offences that may exist already. So they're still there, are statutory offences. It's just the common law power of arrest that's being replaced by statutory power in the bill.
Right, so the common law power of arrest, if this passes, ceases. Is that correct? Okay, thank you very much.
John. Sandra, then Alison, please.
Thank you very much, Convener. Good morning, everyone, and Happy New Year. I think a number of my questions have already been answered, particularly the
Excellent. So this will be a short question.
Particularly the supplementary ones. If I could just go back to the very first one about detained and arrested, which I think has had a very good airing. I just want to pose to the Cabinet Secretary of Justice and also perhaps members of the committee as well. We're talking about basically innocent until proven guilty and the different terminology. But I just wonder if you would agree with me that whilst we talk about the media and the press, there is a responsibility on the media also. And whilst I know that the convener had mentioned the fact it could be perhaps look at some way of explaining it, etc., would you not agree that the media also have a responsibility to basically innocent until proven guilty when this particular law comes in?
Absolutely.
Cabinet Secretary, can we have questions on the bill, though?
Is the bill?
No.
No, sorry, Convener. Isabel, it's about detained or arrested. We've discussed
but the media, I think we've pretty well examined the role of the media and that we can't deal with the media in this bill. Well, I'll let you go on then.
Thank you very much.
You're looking peeved.
I was third to come in for a question, and unfortunately I'm now about 6, but I'm not bothered about that. I just want to clarify that point.
Forgive me, you are bothered because you've mentioned it.
I just want to clarify.
If your colleagues come in for supplementaries, and they are supplementaries, and if you'd come in for them, I would have taken you. Right?
I just want to clarify that point. Would you agree that the media also have a role in this as well, as such as responsibility to people who are innocent until they're proven guilty?
Absolutely. That's, as I say, a jurisprudential argument that, as I say, raised by the convener. But people are innocent and proven guilty, and that should be reflected. Clearly, the courts do have powers if matters are reported inaccurately, and occasionally editors are summoned. And in the main, we try to make sure that we get that balance right.
Could I come on to the next question, which may be a supplementary, it may be a question. It was on what Margaret Mitchell was saying also. And once again, obviously, the bill, I think the first premise of any justice system is innocent until proven guilty, and that's obviously the suspicion of crime, and we talked about the housebreaking kit or whatever it may be. And I know that I've been looking at John and Graham Pearson, and they've obviously got a lot more experience, and certainly looking by their faces, they certainly will come up with some stuff. I just wondered, Cabinet Secretary, we're talking about obviously suspicion of crime, and we've also talked about common law and the new law that's coming in. Would this new law also not only protect suspects, but would it also protect police as well, that it would be clearer for them as they have a ruling of arrest?
Well, I think the intention of this is to make it clear that the common law power of arrest for offences will be repealed and replaced with a power of arrest on suspicion of having committed a crime. It's all other common law powers remain, because there was an issue raised by ASPS, I think understandably, about those who were maybe, what powers would they have if somebody was about to jump off a bridge? Now, clearly those powers remain for police to intercede to protect people from doing themselves, sometimes others, harm. So I think it will provide greater clarity and, as I say, certainty to avoid, I think, the matter correctly raised by John Finney, because I do think inviting people down the police station when they didn't necessarily feel that they could decline was appropriate. It didn't have the same certainty. We do have post-CADR to make sure that we provide access to lawyers, information about rights. So I think this makes it clearer and it retains, I think, what was sought by ASPS, which is a general catch-all about what do they do if they think something dreadful is about to happen. It's not necessarily a criminal offence.
Okay. Thank you, Convener.
Not at all. Very graciously said, Sandra. Alison, please.
Cabinet Secretary, can we turn to the custody of suspects prior to their first appearance in court? You'll recall that the Carloway report outlined concerns about the length of time that some suspects are held in custody, particularly over bank holidays and long weekends and such like. And a number of witnesses during our evidence taking have raised concerns about whether or not we could continue to comply with Article 5 of ECHR if this continues. Are you able to outline what practical measures you're putting in place to ensure that people are not held in police custody for unacceptably long periods of time?
Well, obviously, we presently have courts that sit, for example, on a Saturday when there's public holidays. We do have a working group led by, I think, by Police Scotland, but involving the court service and the Crown to consider what can or should or might be done relating to what is described as Saturday courts. I've never heard anybody suggest a Sunday court. So that's being looked at because I'm aware of the pressures. There's pressures for those who are detaining them as well as clearly for those who are detained. So that's being looked at the present moment, and I'm happy to keep the committee appraised and advised as things progress.
Are you comfortable that we don't need any stronger legislative framework for this within the bill?
I think this is more a matter of practice rather than the legislative framework. I think what we're required to do is to see if it can be worked out and how would it be worked out rather than actually having the specifics. I think there's a general understanding that there are pressures, and this comes not simply from the police who have the individuals detained. I get complaints from sheriffs on a Monday where the court can be sitting into well into the evening, and that, as I say, I think affects all. So I don't think we require any legislative change. These things are not necessarily straightforward or simple, and there's terms and conditions of employees. There's a whole aspect of matters. There's the Crown have to be brought in, because remember, if somebody's arrested for an offence on the Friday, there's a court on the Saturday, then the indictment or the complaint has to be prepared. So it's the detail. So I think we recognise the desire, I think, encapsulated by Lord Carloway. I clearly sympathise with where he's coming from. I think we've just got to make sure that the practicalities, if that somebody is to be appearing in a court on a Saturday, is the Fiscal's office open? Do they have the staff? Can it be dealt with in time for the following morning? So I don't think legislative change is needed, but I can give you an assurance that the committee working group is up, working, and I'll be meeting with officials on a regular basis.
Well, I accept that you what you say about not needing legislative change, but I'm not sure we've got enough momentum in the system at the moment. And clearly your responsibility is to ensure that we comply with the ECHR. So do you have your assurance that this is something that you will take a keen interest in? Oh,
absolutely. I'm meeting with the Chief Executive of the Court Service later this week, and I'm more than happy to take on board any points that the committee may have and may wish to make about the desirability of a Saturday court, and as I say, that's something that I'd be happy to feed back.
Thank you. If I might, Convener,
yes.
One other question, turning to sections 31 and 33, which deal directly with protecting the rights of child suspects. Can we consider the age of criminal responsibility? I know that your own government's 2012 publication, reporting on its action plan to deliver progress against the 2008 concluding observations of the UN Committee of the Rights of the Child, said that you would give fresh consideration to raising the age of criminal responsibility from 8 to 12 during the lifetime of this Parliament. It would have seemed to me this was a good bill to do that. Can you explain why you didn't choose to do that in this bill? Whether you maybe consider bringing forward an amendment to address that anomaly?
Well, I think we would require to consult. I think we've raised the minimum age from prosecution. Yeah. I think it was always unacceptable, and indeed it wasn't taking place in practice, to 12, and we are aware of the calls for the minimum age of criminal responsibility to increase. We're happy to see what we can do within the lifetime of this Parliament, but I don't think it's practical within this bill, especially given that some consultation is going to have to take place, and indeed there are disputes as to just what that age should be.
There's been extensive consultation on the run-up to this bill. Would it have been sensible to take that forward at the same time? What is behind your reluctance?
Well, I don't think we're in a position to do so at the present moment. I think what we have to do is to consult upon it, and we're happy, as I say, to work to have that dealt with within the lifetimes of this Parliament. But not everything can be included within this bill. There's a limit to the consultations that we can have ongoing at any one time. I think we have addressed, as I say, the age of prosecution. I think there are understandable concerns about the age of criminal responsibility, and we're happy, as I say, to give an undertaking to work towards that.
Perhaps
I think you've got a supplementary few minutes to do with the 60s.
Oh, yeah, yes. I do. I mean, it's to do with the whether or not the bill achieves the appropriate balance between allowing 16 and 17-year-olds to consent to be interviewed by the police without a solicitor being present? Do you think that?
Well, I think we do strike the correct balance there. I think, you know, those under 16 clearly are protected, and Lord Carlaway is right there. But I think we've recognised as a Parliament, and we recognise as a government, that in Scotland 16 and 17-year-olds are in a different position. They are still have to be protected, but they can marry, they can pay taxes, they can join the army. Clearly they have to have advice, and that's why I think we've got the correct and appropriate balance, that before they were to they would have to have the presence of, you know, a responsible adult. It would have to take that on board before they could renounce anything. Under 16, I think we take the view that it's sacrosanct, so to speak, but 16 and 17, I think in Scotland, given the positions that they have, the rights that they're entitled to, I think we provide that protection, but I think we have to give them some responsibility to be able to overrule it if they have taken advice on board from a responsible adult.
Yeah, I mean, in the recent Victim and Witnesses Bill, we've defined a child as being up to the age of 18, and we've received evidence from some witnesses, like the Law Society, who believe that somebody under 18 shouldn't be able to waive that right.
Yeah, I mean, I think these things and these debates we've had ongoing, whether it's in terms of what age should you have the right to vote in the referendum, what age can you drive a car at. So we do live in a world where, you know, you can get married at 16, you can't drive a car till you're 17, you know, you can't drink alcohol till you're 18, you can't probably get a high-powered car until you're probably about 25 or 27, given the insurance matters. But we take the view that we do have to protect those under 18. Those under 16 are in a specific position that has to be protected. Those at 16 and 17, whether it's because of their voting entitlement that's coming not just in the referendum, but probably across the board, whether it's marriage or whatever, that they should have some ability to overturn that, so long as they have the benefit of some responsible advice.
Happy? John Finney, followed by Roderick.
Thank you. Cabinet Secretary, the Scottish Human Rights Commission raised two issues. The first is in relation to information to be given to suspects, and they would seek, and I hope you would support, a simplification and a strengthening of the advice given to suspects. Is that something you're considering?
Well, I think we've done that, but obviously the Letter of Rights is now drafted, and I think, as far as I'm aware, SHRC are happy and content with that. I think some of it then is about how you make it available, and as I recall off the top of my head, it's something like 34 different languages. It comes in a variety of scripts. So I think everything that can be done is being done to make that information as readily available and in a manner and format that is understandable.
Given the levels of illiteracy among people who find themselves in custody, is that taken account of?
To add to what Cabinet Secretary said, Letter of Rights has been actually being used in police stations since July, and that is the plain English version at the moment. And as Cabinet Secretary has said, it's translated into 34 languages. We're now actually looking to roll that out to address the very point you're making of any suspects who may be particularly vulnerable or have very special needs, to actually have additional formats. So we're going to be setting up a couple of groups, including an advisory group with third sector organisations who actually deal with such individuals, to make sure that we have the most appropriate formats so it can be as effective as possible in practice. So although it's obviously not a statutory Letter of Rights yet, that is ongoing work. And clearly the Letter of Rights would need to be amended again if this legislation is passed and the rights are enhanced. But that's ongoing work over the next few months.
Thank you. That's very welcome. Could the committee be kept appraised of the progress of that work, please?
Absolutely.
On the second point is access to legal advice there, and it relates to whether clarity is given to individuals that they have the right to a face-to-face contact with a solicitor, not just to speak to them. Now, acknowledging that there are challenges that you alluded to in other matters regarding the geography of the police, is that something that can be given some regard? Because the role of a solicitor isn't simply the advice, it's sometimes to check on the conditions in which the individual's been held.
Yes, if I may answer that one as well. I mean, we're trying to keep some flexibility in the legislation, but the normal default would be that the suspect would have the right to choose. But we didn't want to place too much legislation saying it has to be face-to-face, because it might be in some circumstances that's not appropriate. Obviously, if the
what
suspect
circumstances would it be inappropriate for a suspect
well,
to
it may
give
be they'll
advice
speak to their solicitor, and their solicitor won't think it's necessary for them actually to come out. They may not be being questioned. It's just to keep some flexibility. If they're actually being questioned, then there is a right that the solicitor is present, which is an enhancement from the current position. But it may be for many cases actually a telephone call is sufficient. There may be other circumstances where that just wouldn't be appropriate. So that would be a matter that the police, with obviously the suspect being told that they have a right to speak to their lawyer, discussing with their lawyer, and the lawyer may choose to come down. But it is just to maintain flexibility. It's not to, this bill very much enhances the rights to legal advice for suspects who are taken into custody. But what we want to make sure is that in practice it works most effectively for all those involved, particularly the persons who are in custody, as to what's appropriate in individual cases. So it's really for them to decide in most cases what might be appropriate.
Can I just clarify, if these discussions taking place with the Law Society have previously made representations regarding the very circumstances you say where an accused changed their mind and the question of reimbursement of fees for a lawyer who had travelled the distance, only to find that had been cancelled?
Yes, we have obviously spoken to the Law Society about the bill, and the legislation does enable a suspect, for example, to change their mind. It may be initially they don't even want to take legal advice, even having been informed of their rights, and say, no, I want to waive my right to legal advice. That obviously can't happen in certain categories, such as for vulnerable persons. But even if they choose to waive the right to legal advice, the bill would certainly not stop them from changing their mind and saying, actually, now I've decided I do actually want to obtain legal advice, and therefore then for their solicitor to be contacted.
Some of this is custom and practice from the lawyers. Even when I practiced and you got a call from an officer such as yourself or Mr Pearson in the early hours of the morning, if it was a very serious charge in the likelihood where you were going to go down, if it was a less serious charge on somebody who was part experienced, then you basically went back to your bed. I think what we find is that clearly lawyers are clearly speaking to their clients, giving them advice over the phone. If they feel it's appropriate because of the nature of the charge or the nature of the client, then they are attending. But a lot of the decision to simply deal with it by telephone actually comes from the lawyers themselves, who have no desire to go to the police station.
Absolutely, but if summoned 30 miles to go to a police station to arrive there to find the accused or suspect has changed their mind, will the lawyer be reimbursed?
That would be a matter for the Legal Aid Board. I have to say I don't know the particular rules or regulations there, but we can...
Kind of wandering off the bill here, you know.
Are we?
Yes,
Right.
the legal aid costs are not in this bill.
Okay,
normally, equally, you have both a duty agent scheme and you have obviously the contact line that the Legal Aid Board have set up.
Okay, thank you.
Yes, they're not in the bill, John. They're not. That's in another bill. Okay. You're giving me a quizzical look, but I'm telling you that's a fact. Sandra, you have a... Now, it better be a supplementary. I feel I'm being tested this morning.
I feel as though I'm in court or on trial, but thank you very much, Convener.
Close.
It is a supplementary. I was very interested by Ms Baha when you mentioned about working with the third sector to give information and advice. From past experience in other committees, there was a real problem, people who were deaf and dumb, and being able to get interpreters and that type of thing. Would you be looking at that in the voluntary sector as well, being able to work with them? Could we get an appraisal as you're going along with that?
Yes, I mean, there is, I'm aware there's another EU directive as well about interpretation, but that may be separate with languages. But yes, that's the first. I mean, we haven't set up the group yet, but I think that would be the first thing to do, is actually find out where the most in need groups might be who are currently in custody for other kind of formats. So certainly that will be one of our first tasks, is actually finding what would be our priorities. Good. And certainly over the next few months, we're more than happy, once this group is set up and we start seeing the kind of areas where we think we've identified where other formats may be appropriate, to actually write to yourselves and let you know that, and obviously...
Close to the bill, but we are kind of drifting a bit, because, I mean, an arrest is challengeable. All these processes are challengeable if the party don't understand the proceedings. So I'm not tetchy. I'm just trying to keep to the facts of the bill and not drift into other areas, interesting though they are. I have Roderick. I hope this relates to the bill. I'm sure as an advocate it does.
It definitely relates to Part 1, Section 14, investigative liberation. 14.2 says, releasing a person from custody, a constable may impose any condition that an appropriate constable, deemed to be an inspector, considers necessary and proportionate for the purpose of ensuring the proper conduct of the investigation into a relevant offence. There seems to be a kind of a right, if you're concerns about the conditions, to apply to a sheriff to have it reviewed. Is it your view that this bill says enough or balances the rights of an accused in these circumstances sufficiently? Or, for example, if, as has been suggested by one of the witnesses, I think curfew conditions were imposed, which would certainly have an impact on liberty. Have we got enough balance in the bill to protect the rights of the accused here?
Well, I'm happy to take on board any thoughts that the committee may have. Ultimately, I think these details have to be considered by the court to some extent, its ability to get it to court, because clearly if we're looking at the accused rights, then we have to have some appeal, and the appeal as such, albeit not a formal legal appeal in the terms, would be from the decision of the senior officer to the court. And clearly in years to come, no doubt the court will set down what they view as appropriate. So some of these things, I think, have to come around from working parties, because a lot of these things where the concern has come from in the main has been perhaps also from the rights of victims in terms of domestic abuse, to make sure that people are being released and they're not going to return to the matrimonial home or into an area. So I think some of these things are best dealt with at a more local level, where senior officers will work with the judiciary, get some indication of what is acceptable or not and how they wish to deal with matters. Equally, when it's not, I think what we have to do is for them to be able to get to court as quickly as possible to challenge that. I think providing greater detail, I'm open to that in the bill. I find it difficult to see how that could be dealt with, because a lot of these things might be geographically or individually specific, relating to the nature of the curfew or the nature of the street or the address that you cannot go to, because understandably in some areas it may be in terms of prolific shoplifting that you're denied access to the town centre. It could be because it's an assault that you're denied access to a housing scheme. But I'm open to any thoughts or suggestions.
As to thank you for that, Cabinet Secretary. As to the 28-day period itself, do you think that's the right length? Some police witnesses have suggested that we should be able to apply for a longer period.
That was what Lord Carloway came back. I think in the main 28 days should be sufficient. There may be some challenges in some aspects where it relates to forensics or other aspects, but I think we have to balance this, as you said at the outset, with the rights of the accused. So again, I'm open to any thoughts, but 28 days seems to me to be an appropriate period. But I'm open to any thoughts that you may have, and I think probably for the accused and indeed for victims and witnesses, you need some finality and certainty, because you are in a bit of a perhaps limbo, and therefore I think keeping it tight. So I'm happy to take on board any thoughts, but 28 days seems to me to be a reasonable period.
And is it your view that the 28 days has significant resource implications? Some people suggesting that the whole investigative liberation scenario would have a resource implication?
I can't for the life of me see why, because it seems to me that whether they were remanded or detained, you would probably be doing the same type of work anyway. You'd be making further inquiries, whether those inquiries are technical through computers or through forensics, whether they're simply investigatory through dogged police work. Seems to me it's the sort of work you'd be doing anyway. What investigative liberation does is perhaps provide some greater flexibility for the person who is under suspicion.
Thank you. Just if I may just ask a short question on post-charge questioning.
Investigative liberation. If I just get this in my head, you're arrested, but you're not officially accused at that stage. Has there actually been a definition of what you've been arrested, the crime you've not been charged? So is there a crime for which there's a label to it, let's put it, attempted burglary or something? Because what concerns me is, if you're arrested in investigative liberation, you could be trying to find something to pin on somebody, to put it in common parlance. Or you've arrested them for one thing, and you go out in investigative liberation, you find something else, but like a fishing warrant, trying to have a fishing warrant. Am I on the wrong path? Or is it going to be pretty narrow about what they're investigating once somebody's liberated?
The person will have been told the general reason for their having been arrested.
What do you mean by general reason? How broad? I mean, I'm thinking about
But just
somebody...
as they would now.
I beg your pardon, sorry, Roderick.
I think 14.1 gives some indications. That would be a relevant offence.
Yes, by virtue of authorization given under Section 7, but just Section 7 just tells you a person in custody with a warrant and since been arrested, the person has not been charged with an offence. Doesn't actually tell you that it's going to be pretty specific.
I think we have to be clear about the purpose of the criminal procedure that the police are actually undertaking at that point, and the purpose behind it is to investigate a crime. So,
yeah, but what crime is what I'm getting at is does the person who's been liberated, they've got an idea, or the lawyers have an idea of what on earth they're accused of?
Police are clear about what is the complaint that they've received in relation to what offence has been committed. The charge might change based on the investigation and the information they gather, but they will be clear about what is the investigation they're undertaking, and the suspect would be clear about what that investigation related to and what the alleged offence was.
So if something else turns up that's nothing to do with whatever they were originally arrested on suspicion for, that could form another.
Yeah, it would be a separate matter, as would be current practice at the moment. If there was a separate matter, it would be dealt with separately.
Okay.
That's as if that's at the moment. If somebody is, I mean, the normal view about caution and charge obviously only relates to the reply that's given, but people can be arrested or detained on breach of the peace and cautioned and charged. But if other matters come to light, then the complaint or indictment that could be served by the Crown can be significantly different, and the caution and charge only relates to the reply.
I understand that, but investigative liberation, does that involve digging into material things, going in, that goes into the computer, going into their cupboards, into their factories or whatever, rather like you would if you had a warrant to search?
What it's doing is allowing the police time to undertake investigations and acknowledging that in modern society, investigations can be rather more complex.
I understand that, but so am I understanding people will still have to apply for a warrant to search, police officers and so on?
Yes, absolutely.
But this might be able to supersede that, would it not? Because you could just certainly couldn't do that.
Change the warrant. No. What it does do is avoid the accused being perhaps remanded, or the police not having the specific evidence when, as Aileen says, in terms of the world in which we live, access to computers or forensics. But certainly doesn't give them any rights to go in and do aspects that wouldn't be otherwise requiring a warrant.
Well, that's clear. Thank you. That's what was concerning me. In the same line, is it?
Just seek some clarification, Cabinet Secretary, of the logistics of how this liberation, investigated liberation would work. Now, it's over a 12-hour period. It could be for an hour, half an hour. It could be someone released again, all this time officially under suspicion, brought in for 2 hours, released again, brought in for half an hour, released over a 28-day period. Are you confident, because certainly the Scottish Police Federation have raised real concerns about this, and it's something that we've raised in the Police Committee, that the IT system, which is being developed at Police Scotland as we speak, is going to be able to cope with this? Because it seems to me there could be a very complicated set of recordings required here.
Well, I'm confident the IT system will be able to cope. I think in the main, people will be released for a period of time to return, which will allow the police. I mean, I think we're mixing up investigative liberation there with periods of detention. But the computer system, as we well know, requires to be upgraded and to improve. That is a priority for Police Scotland, and they will ensure that it is fit for purpose for both the current and indeed future issues and challenges.
Roderick, you had a different
short question on kind of post-charge questioning. The Scottish Human Rights Commission take the view that the bill should provide that no inference should be taken from silence, no adverse inference, and that should be on the face of the bill. What would you say to that in the kind of what's hopefully relatively rare circumstances where there is post-charge questioning?
Well, that would seem to me to be the current circumstances that would arise anyway. More and more interviews in the presence of a lawyer and under caution are dealt with by the simple response that, on the advice of my solicitor, I have no comment to make. If that is post-charge questioning advice, then to some extent it's probably the same circumstances that we've seen in judicial examinations that previously were the way in which you would have tried to deal with this. And certainly, even in my own limited involvement with judicial examination, I have to say the advice I gave to the client was, on the advice of your solicitor, you have no comment to make. No real questions can be asked, but if that's the line that the accused sits with, then I don't see how any inference can be drawn.
Perhaps just to add to that as well is that we would see the position on post-charge questioning being very much as a position on pre-charge questioning before somebody's officially accused, where of course there's a right to silence and somebody doesn't have to say something. And actually, just to add into what Cabinet Secretary said, right now in legislation, when there is judicial examination, it's not adverse influence as such, but there is a provision which enables in certain circumstances comment to be made during a trial as a result of something that happens at judicial examination. So legislation tends to actually have to put in to enable comment to be made rather than the other way about. Rather than you have to put in legislation and saying no adverse influence be made, the assumption is right to silence and people have a right not to say anything. That's the stand.
That's it. Yeah, then you'd answer that point. Okay, thank you.
And Elaine.
There's a question on Section 33 and the support for vulnerable people, where in particular people suffering from a mental disorder, which is defined as having the meaning given in Section 3281 of the Mental Health Care and Treatment Scotland Act of 2003. Now, this section requires the constable to assess whether or not intimation should be sent to a person suitable to provide support, and also, in terms of other matters, the constable has to assess whether or not the support is required. Is that not rather a burden on the constable involved, that they should, for a start, be aware of the definition of mental disorder in terms of that Act?
Well, I think we have had the definition now for some considerable time. Mental disorder is defined as mental illness, personality disorder, learning disability, which is tried and tested practice on which police have been assessing the vulnerability of suspects, accused, victims and witnesses for many years. So I tend to think that the term mental disorder is perfectly understandable in the main. We're not asking them to act as psychiatrists as such, but simply to make an assessment on somebody's ability. And as I say, I think that's routine custom and practice and has worked well.
So you wouldn't agree with the Law Society's concerns that this might be difficult for a constable to assess whether somebody has actually had a condition?
No, I think that officers have shown over the years their ability to make an assessment that's appropriate, and as I say, where they have doubts or aspects, then clearly they go to a police surgeon.
Right, I'm going to stop this particular section and suspend for, thank you very much to the other witnesses. Cabinet Secretary is staying, and we'll suspend for 2 minutes to allow the officials to change places, and we move on to the next sections. Right, thank you very much. We'll press on because we're dilly-dallying a bit today, and we're moving on to parts 4, 5 and 6. And I now welcome to the meeting, in addition, the Cabinet Secretary, Elspeth MacDonald. Oh, beg your pardon, I'm not making her at all. I welcomed her already. But you're still here.
I haven't moved. Thank you.
You haven't moved. Wait a minute, where am I going? In addition, I'll need to learn to read my script. In addition, I welcome Kathleen McAnulty, Police Officer, Criminal Justice Bill Team, Philip Lamont, Head of Criminal Law and Licensing Team, and Anne Thompson, Head of Workforce Sponsorship Unit. And I've still got Leslie Baga and, of course, Elspeth MacDonald. We've settled it now. Thank you. Can I now move on to questions, please, members? It's what am I doing now? It's sentencing and appeals and so on. Right. Elaine?
Yeah. It's a questioning on delays in appeals, and I was just wondering why the provisions in the bill concentrate on the initial stages, the late notice of appeal and so on, rather than the progress of appeals. And I'm sure that the Cabinet Secretary will remember the case of Adam Carruthers, who was one of my constituents, convicted of rape of a couple of also my constituents. There was a series of appeals which dragged on, and I had at that time quite a lot of contact with one of the victims who felt that the process of appeal was a further, where she was having to relive the having been involved, the victim of the crime, that actually was an additional burden on her. And the bill doesn't seem to address that part of what is often a very traumatic.
Can I ask, is that proceedings concluded? Otherwise, we're
yes, it is. It is. Yes, and in fact, he's released. He's actually served his sentence. For me to say it, he's served his sentence. Is released, so we can discuss it.
Right.
But that doesn't actually that part of the experience of a victim where the appeal process can continue to torment the victim doesn't seem to be being addressed.
I think it's a fair point you make, and that's why the legislation has to try and take cognizance of the rights of victims and those involved in the court process, because the ongoing appeals that have to be there as a consequence of ECHR, and I don't think anybody challenges that, do have significant pain and impact on families. I think there's two things. One is we do have to have some certainty and clarity, both for those who seek to appeal and indeed for those who are affected by it and victims, which is why I think Lord Carloway has correctly put in specific timescales, subject to exceptional circumstance where there's reason that it hasn't gone in. Equally, I think some of the other aspects you touch upon, some of that's down to case management, and that really has to be down to the judiciary. Some of that will be dealt with and hopefully benefit through court reform, but that's down to the individual case management by the appeal court, by the judiciary, and I think this sets a correct balance. But I do know that certainly the Lord President and indeed the Lord Justice Clerk both understand that delays affect not simply the rights of the accused, but the rights of the victim. So it's a fair point, but I think the latter aspect is more about case management. The other aspect relates, as I say, to what has to be in the statutory provisions.
So this bill is not the place to deal with that aspect. It's not actually legislative.
Well, I think Government and Parliament would always hesitate to run in case management of how proceedings actually run in court, because aspects, evidence, all these details have to be brought on. How long should the case run for? All these things should be dealt with, I think, by those who are correctly set up or independent, and why we passed the Judiciary Act. I think what we're doing here is giving not just the accused clear intimation of what the timescales are, if they're going to mark an appeal, whether against sentence or conviction or both, when they have to do it by. That's also clear so that victims can understand that if it's not in by that specific time, then barring exceptional circumstances, it isn't coming in. Equally, whilst I can understand that the continuing ongoing delay in an appeal, I think some of that has to be left to those who are administrating it. If there's new evidence that comes in, if there's additional evidence that has to be obtained, I think that has to be left to the courts. I think we would face difficulties if we set a position that an appeal had to be dealt with within a period of X. If somebody said, well, I've got to get additional evidence and it's going to take a period that's X plus Y.
Just while we're on that topic, we had evidence from the Law Society of Scotland that the exceptional circumstances test might be unduly restrictive. I just wondered if you were able to comment on their view.
I don't believe so. I think exceptional circumstances is, again, it's for the judiciary and for the appeal court to interpret that, but I think there's a common parlance of what's viewed by exceptional circumstances. Just because you couldn't be bothered or you hadn't, quite made up your mind doesn't constitute exceptional circumstances, but ill health, clerical error, some of these things can all be exceptional circumstances. So I think it's something that the appeal court can work with, and indeed I think solicitors clearly understand it has to be something beyond just it wasn't capable or didn't fit your schedule that day.
Isn't that the case anyway just now? Would that not be the way the court behaves anyway if it's just been sloppiness on the part of an agency rather than the issues you're...
Yes, and which is why we've decided not to go down the route of sanctions. That's a matter for the administration by the courts of the system, or indeed for those who deal with professional practice.
John Pentland, please, followed by Roderick.
Morning, Cabinet Secretary.
Morning.
In section 71 of the bill, you talk about extending the maximum term for weapon offences and from 4 to 5 years. And at a committee meeting on the 19th of November, witnesses were questioned on this topic, and they were, however, unable to provide much guidance in relation to whether or not there is a need for increased sentencing powers. So, could you maybe, Cabinet Secretary, what evidence do you have to put this into your bill, to propose this extension?
Well, we've made significant progress in tackling knife crime in Scotland. We've seen a 60% reduction since this government came into office in terms of handling offensive weapons. But we have had tragedies, and every member of this committee and probably every area of Scotland has been touched in some shape or form by it. And as an administration, we are not prepared to take our foot off the accelerator in tackling and driving down knife offences, because they affect families, communities, the country. And therefore, we think we're heading in the right direction. The period of average sentence now for handling an offensive weapon is up over a year. I think that gives the court the appropriate balance where they think that the discretion and some element of leniency can be shown because there's some background to it, then they express it. Equally, when it's quite clearly that there was malevolence and malice and other aspects, then I think they correctly bring in tough sentences, and we fully support it. So this is about continuing to make Scotland safer and continuing to address an issue that has scarred Scotland, is getting better, but we would be remiss in being complacent.
And if Section 71 is approved, what impact do you see the availability of longer sentences expected to have in practice?
I think it just gives greater discretion to sentencing judge or sheriff. Our position has always been that it's for the judiciary, which is why we've never supported mandatory sentences. And indeed, when we have a sentencing, where the average sentence in Scotland is over a year, why would you wish to impose a tariff mandatory that's less than that? So this is about simply having the discretion there to recognise the significant harm it can cause. It will be for the judiciary to decide whether they wish to impose it. I think they should have that right, but whether they do so will be for them to decide, and on clear facts and circumstances that would merit it.
I like that, yes. Yes.
Yeah, supplementary on that. The bill, however, doesn't seek to alter the maximum custodial sentence for summary offences. Can you explain your rationale for that?
Well, that's again a matter for the Crown to decide whether something should be on summary on indictment. And clearly, if a sheriff felt his sentencing powers were in appropriate. And that's really a matter for the Crown and for the judiciary. They'll have to decide whether they wish to go on, summary complaint or on solemn. But
it might be helpful to clarify that the current maximum for handling an offensive weapon when prosecuted at the summary court is 12 months. That's the maximum general sentencing powers of the summary court. So if we were to increase that, we'd actually be going beyond what's already been provided for in other legislation about a general maximum. So that's why we haven't done that.
Okay. Okay. Do we have the figures, or may have the figures, for how many sentences of 4 years have been dished out?
It's very few. I think the most recent stats indicated only 1 or 2, and sometimes it's complicated because there may be other offences wrapped up. So it's true to say that not very many people received the maximum, but certainly, as the Cabinet Secretary explained, we feel this is about empowering judges to have it available, an increased maximum available, perhaps for repeat offenders who have a track record of using knives, who once again are caught carrying knives, but it'll be for them to decide in the individual circumstances of a case.
Thank you. John, do you? Roderick?
If I may, I might move on to a question of human trafficking, which has been moving quite fast of recent weeks and months. I welcome sections 83 and 84 of the bill, and I'm also read your letter to the convener dated the 16th of July, but would you, for the record, just like to outline what the government's thinking is in connection with human trafficking, and what do you say to the critics that say that Scots law should have a definition of human trafficking somewhere?
Well, statutory people tackling aggravation, I think, is the first stage. I mean, what we are doing as a government is, first of all, to recognising, is there a problem? Yes, there is. We're aware that people have been trafficked here, and we're aware that Scots have been involved in carrying out trafficking and were correctly sentenced in other jurisdictions, in particular in Northern Ireland. So the issue is one that we're aware of. The first step that we believe is necessary was to bring in the general aggravation, because we're conscious, I think, that that will help raise awareness. It will also allow evidence to be led. So I think it will make it easier for us to deal with appropriately those who perpetrate it. We are, I think, persuaded that there has to be more than that done, and the question is then, how do we do it? Obviously, Jenny Mara has proposed her own Members' Bill. Equally, we're in discussion with the UK on their modern slavery bill, and there are discussions ongoing there, and indeed I attended an event down at Number 10, chaired by the Prime Minister. So we are putting in the general aggravation to show a willingness and a desire and the necessity of dealing with it. In terms of the broader aspect of the legal definition, we are happy to see what is best. If matters can be dealt with within the modern slavery bill, well, we recognise that by the nature of this criminal offence, it crosses jurisdictions. So we are in discussion with the UK as to whether or not this will apply to Scotland. If it is capable of appropriately applying to Scotland, we'll be more than happy to take it, because it will be the quickest way of making sure that Scots law is fit and appropriate.
Thank you.
I'd like to ask the Cabinet Secretary my own particular interest of Section 82, the references about SCCRC, and perhaps the Cabinet Secretary will recall a little tussle which I lost, not for the first time, under the Criminal Procedure Legal Assistance Detention Appeal Scotland Act 2010, that emergency legislation, which introduced, on the back of Cadwell, I think the idea would be a flood of applications to the Criminal Cases Review Commission. It introduced a gatekeeping role for the High Court to refuse referrals from the SCCRC, and a second part, which was that even if an appeal was successful, the appeal would not, the sentence would not be quashed because it wasn't in the interest of justice. So that was the background then. I'm glad to see that the first part is going the gatekeeping role. I think that's the case. Not glad to see the second part still there, because for the life of me, I don't understand why, if an appeal is successful on its merits, the High Court, sitting as the appellate court, can then reject that appeal on the basis it's not in the interests of justice, but in the interests of finality and certainty. And I don't think the example that Lord Garlaway gave was helpful that somebody might plead guilty in the middle to the crime in the middle of the appeal proceedings, because I think that's, frankly, you know, like a very unlikely event. So, can I ask the Cabinet Secretary why we are retaining this? I don't understand. You did not have a flood of applications after CADR to the SCCRC. It seems to be in the face of justice. You're always talking about access to justice. Seems to be in the face of it, fly in the face of it.
Well, I think the proposals in the Act strike the correct balance. I'm aware of your concerns, Convener, and I think that the change here, I think, retains what I think is necessary and equally takes on board the concerns that you have. I think it's quite clear the role of the SCCRC that we cherish in Scotland is to consider where there has been miscarriages, to seek that review. I think that it's important that the High Court should take cognizance and check to see if there's a miscarriage of justice. But I think at the end of the day, the High Court of Justiciary is sitting as the appeal court. I think they are the ones that ultimately have to decide if something is in the interests of justice. I think these things are likely to be very sparingly used or considered. Equally, I think the point made by the Lord Justice Clerk does, I think, have merit. You could have circumstances where, for whatever reason, matters at the court first instance weren't dealt with appropriately, and clearly a miscarriage had taken place. But if an admission had taken place, it does seem to me that the Court of Appeal should require and should be able to take into account the interests of justice. Otherwise, you might end up with the absurd situation that somebody would be acquitted by the Court of Appeal, and the following week you'd be considering an application under the double jeopardy on the basis that clearly there was good reason to believe that a crime had been committed.
No problem with that. I have no problem with an application now that we've got rid of double jeopardy. My concern is that in any other appeal process, if the appeal is successful, it's successful. But if it's a reference in the SCCRC, who've already applied an interest of justice test before referring it on, the appeal is successful, but because solely it has come from the SCCRC, it's different from any other appeal. And that's my problem. The principle should be the same for every other appeal, that if the appeal is successful, it is successful.
Well, I see where you're coming from, but I think appeals that come from SCCRC in the main tend to be a lot more historic, because they are the situation in which years have passed. Every other avenue has been considered. There's probably a great deal of timescale and events. And at the end of the day, I think the SCCRC has to be protected and cherished in what it does in terms of allowing that review. What I think, though, is fundamental in that the High Court of Appeal should remain the ultimate arbiters, not simply in terms of deciding whether the rules or not, in terms of whether a miscarriage had taken place had been applied, but whether it is ultimately in the interests of justice, and therefore the ultimate arbiters in this, the SCCRC make the review, but the ultimate decision should be made by the High Court.
Clarify, therefore, in appeals that go through the normal appellate procedure rather than referrals from the SCCRC, even if an appeal is successful in the merit, an ordinary appeal going forward in that way to the High Court, in the normal process, they apply an interest of justice test and would reject an appeal even if on the grounds it was merited. No.
No.
But only if it's from the SCCRC that will have that extra test.
That's right.
Well, that's my problem.
Well, I think, as the Cabinet Secretary explained, it reflects the fact that since the Commission were established in 1999, they have always had to apply the interest of justice test as part of the consideration, and that reflects, as the Cabinet Secretary said, often the type of case they deal with and the special role they have. And what Lord Carloway has recommended, and we agree because we've obviously put it into the bill, is that ultimately, yes, the Commission should review cases and be the avenue by which cases come back to court, and they have to consider interests of justice in so doing, but shouldn't it be the case that the High Court should also apply the same tests? And that's what's in the bill.
It's already been applied, but the High Court's going to apply it again.
Because of the type of cases we're talking
about.
And
we're just going to differ on this. Type of cases, to me, is making two classes of appeal, which is completely unnecessary and didn't exist before. And in fact, The sifting procedures, you know, from the SCCRC is very rigorous, and they have a very good record at either having success on sentence alone or on conviction and sentence. So the sifting procedure is pretty tough. So my concern is that we've got this in the other end. I understand why it was put in at the beginning, but I, for the life of me, don't understand why we're retaining it. And I have to tell the Cabinet Secretary, give you notice, I'll be lodging an amendment to delete and to take us back to where we were I'll try again pre the Act of 2010, and we'll see if I'm successful this time. So there you go. Somebody else wanting in now? Roderick, something different?
Different subject.
Yes.
Police Negotiating Board, Cabinet Secretary. There were some concerns expressed, I think, from Callum Steele, Scottish Police Federation, as to whether the remit of the negotiating board would include the terms and conditions of all police officers. Can you give us an update on government?
I mean, the only matter we rated here was from Scoposa, and they've indicated their willingness and desire to come within. We have never pushed. We've always taken the view that better a willing volunteer than a reluctant conscript. We had hoped they would come forward, and clearly they do. So all police officers, from the newest constable through to the Chief Constable, will be dealt with by the board.
We're exhausted? We're exhausted. Thank you very much, Cabinet Secretary. I'm now going into private session.